For the record, Elliot Blumberg on behalf of Ms. Glazer, who's appearing by Zoom from my office.
Thank you. We are here for a status conference. Do we have a resolution of this case, Mr. Blumberg?
Yes, we do, Judge. Ms. Glazer is going to be pleading to operating under the influence. Count 2, which is, I believe, breaking and entering or enter without owner's permission, will be dismissed.
Mr. Fourtier, is that an accurate statement of the agreement?
It is, Your Honor.
All right, Ms. Glazer, you've heard what the attorneys have said. Is that what you want to do today?
Yes, Your Honor.
All right, there are a number of rights that you have right now, so let me tell you what they are so that you can make an informed decision about how to deal with them. If you enter a plea today, you would be giving up all of the rights that you would have at a trial. Those include the right to have a trial by a judge or by a jury, the right to see, hear, and question the witnesses against you, the right to present evidence and witnesses and get an order from the court called a subpoena to require those witnesses to appear and testify, the right to testify yourself or to remain silent. And if you chose to remain silent, that silence could not be used against you. The right to be presumed innocent until proven guilty beyond a reasonable doubt and have that burden of proof remain with the prosecutor at all times. And finally, the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
I do.
Do you have any questions about any of those rights?
No, Your Honor.
Knowing that, is it still your desire to enter your plea today?
Yes, Your Honor.
All right. Can I have you raise your right hand so I can swear you in, please? You swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do, Honor.
All right. Go ahead and put your hand down. Has anybody promised you anything other than this plea agreement to get you to plead today?
No.
Has anybody threatened you in any way to get you to plead today?
No.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
Do you wish to have any additional time to discuss this matter with your attorney?
No, Your Honor.
All right. The offer, as I understand it, is that you're going to plead to count 1, which is operating while intoxicated, a misdemeanor offense with a maximum penalty of 93 days and or a $500 fine, and count 2, which is illegal entry, that is entering without owner's permission, would be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
All right. The charge of operating while intoxicated says that you did operate a vehicle on or about June 1st of 2025 in the state of Michigan in Otsego County upon a highway that is Spar Road while being under the influence of alcoholic liquor. Is that true?
Yes, Your Honor.
What vehicle were you operating at that time?
2016 Chevy truck.
And how much had you had to drink prior to operating on Spar Road?
I had a lot.
What had you been drinking?
Oh, what have I? Just beer, Miller Lite.
All right. And do you believe that that amount of alcohol that you drank put you under the influence, meaning that you're not able to drive in a normal manner?
Yes, Your Honor.
All right. Do either counsel have any additional factual basis questions?
No, Judge, I think you've complied with the court rule and there is a factual basis.
All right. Any other promises, threats, or inducements that either attorney is aware of that's not been placed on the record?
No, Your Honor.
No, Judge.
All right. Let me catch up on my paperwork. I do find that there's been a proper factual basis given to me as she's admitted the elements of operating while intoxicated in that she drove on public highway while being under the influence, not able to drive in a normal manner within Otsego County on the date in the complaint. And I believe that she did so knowingly, intelligently, and voluntarily from the answers to my questions. So I would accept that plea. Mr. Blumberg, I do see a substance abuse assessment submitted on behalf of your client, as well as a number of character reference letters. Do you intend or do you wish to proceed directly to sentencing today?
Yes, Judge, if the court would feel so inclined, we would ask for you to do that.
All right, Mr. Fourtier, do you have any objection to that?
I don't. However, I don't have copies of any of what the court's referencing.
Judge, I have a note in my file that says it was sent to the prosecutor's office, but we'll send another copy.
There is a substance abuse assessment summary from Up North Psychology, Jeanette Sayre, that the court has stamped in on July 15th. It recommends that, or says that Ms. Glazer does not meet the criteria for substance use disorder, and her actions were most likely due to ongoing stress, emotional dysregulation, although it does recommend that she continue to attend the outpatient counseling weekly to address her substance use and mental health concerns, and also make some recommendations as to CBT therapy and EMDR therapy that she may benefit from. And then the character reference letters include from Anne Marie Cusiel, Cheryl Viviano, Camille Kenyon, Teresa Taskey, Tina Sumanpao, and Wendy Foreman, all of which are unhesitatingly positive and glowing in their recommendations for her and about her. And then there are also some, looks like screenshots of Alcoholic Anonymous confirmation that she's attended those from, looks like June 27th through July 13th. Mr. Fourtier, do you have any objection to moving forward today, even though you haven't seen those documents?
No, Your Honor, I have no objections to that. I actually recognized some of the names that you had mentioned for the character. So.
All right. Ms. Glazer, what I'm going to do is I'm going to give each of the attorneys an opportunity to tell me what they think should happen at the time of sentencing, and then I'm also going to give you an opportunity to address me prior to sentencing as well. So I'll start with Mr. Fourtier. Is there anything else, sir, that you would like me to know prior to sentencing?
Yes, Your Honor. So as far as the substance abuse evaluation goes, with it stating that she doesn't meet the criteria for substance use disorder, I'm obviously not the evaluator and have access to, the history that Ms. Sayre would have had. But I do have at least the knowledge of the facts of what went on in this case, and the lab results, her blood levels were a 0.207. And I've been around not a necessarily long time, but long enough to know that a person doesn't get to a 0.207 without a history of drinking. She does have a prior impaired from 2007, which is why this remained as a first offense. But again, that number, that 0.207, most people would be passed out, puking on themselves at that number without, for lack of a better term, to say practice of doing that. So it's a little concerning that the evaluator doesn't classify any substance use disorder based on that. However, I would ask that the court at least take into account those facts in order that Ms. Glazer undergo some sort of treatment. It's encouraging to see that she's at least been attending AA meetings and has support of members of our community. So it sounds like she's got a good support system in place to succeed. And hopefully, if she does participate in those things meaningfully, that she'll learn from this, she'll move on, and hopefully we won't see her back. In addition to any sort of outpatient treatment that the court orders, I would ask that the victim impact panel and the alcohol and highway safety class also be ordered as part of any probation.
Thank you. Mr. Blumberg, elocution.
Thank you, Judge. With all due respect to counsel, while he's familiar with the lab reports and there is no suggestion that they're not accurate, what he doesn't know is, and what is important, I believe, for the court to understand, is the circumstances that brings Ms. Glazer before the court. This incident that resulted in her arrest occurred days before her divorce trial, terminating a very, very long-term marriage. Her attempts to enter the house is the home where her husband was residing in an attempt to try to preserve what was a failing marriage. And certainly she will be the first person to acknowledge her choice to drink and then go to the house and then operate a motor vehicle was incredibly foolish and dangerous. She has taken serious, meaningful steps to right that situation. She is actively engaged in Alcoholics Anonymous. She is actively involved in outpatient counseling. And I think as another matter that the court perhaps should consider, Ms. Glazer has been going through a series of major surgeries as a result of an attack by a dog, resulting in her inability to use one of her arms, the inability to work at this point. So it has been sort of the perfect storm of really bad things that have happened to her. And again, she will tell the court in her own words how remorseful she is in acknowledging the choice that she made that put others at risk. So in the end, Judge, we're asking the court to certainly order those things that were contained in the alcohol assessment. That is to continue counseling, to continue AA, and as the prosecutor's office is requesting, highway safety class would certainly be appropriate. But I don't think any period of incarceration, given the circumstances and my client's lifetime of good behavior and contributions to this community, would be warranted. So we would ask the court to adopt those recommendations contained in the assessment and any other sanction that the court feels is appropriate. Thank you.
Thank you. Ms. Glazer, you also have the opportunity to address me if you'd like. I'd be happy to listen to you at this time.
Your Honor, I just want to apologize. I'm embarrassed. I'm disappointed in myself. This has been bothering me ever since it happened. I'm trying to take steps forward. I want to start my new chapter now that my divorce is over. Like I said, I've been going to counseling every week. I text her throughout the week every day. And I've been going to AA, and I'm just trying to make my life better. And I am so sorry and disappointed and ashamed of myself.
Thank you, ma'am. I appreciate the heartfelt thoughts there. I am not going to put you in jail. I appreciate the storms that life has thrown at you in the time period that leading up to this incident. Not to say that because bad things happen, you get to make bad choices, but I certainly can understand the difficulties that you have been going through and are going through at this moment. And I don't know that jail is necessary. And I'm pleased that you have taken steps to address the problems before I ordered you to address the problems. And I think that in reality tells me more than anything of why I don't need to put you in jail. You've begun counseling well in advance of sentencing. You've gone to AA. You are working on your mental health issues. You are involved in self-help groups consistently, and you've shown me that. And then the icing on the cake is a number of letters of which I previously referenced, all of which give me a glowing recommendation of you to say that you are not somebody who is just now beginning to try to do the right thing, but you've been trying to do the right thing for a very long period of time. You may have lost your way a little bit because of the depth of the pain that you had to go through, but it appears that you're back on track again. So for all of those reasons, I am not going to treat you as a normal second offender. I agree with the prosecutor in one aspect, and that is a blood alcohol level of 0.2 does tell me that you were not an inexperienced drinker, and this was not just a one-off or you were drinking for a long time in a large amount, and it's good now that you recognize that and you're taking steps, but it's not going to be tomorrow you're done with this at that level. You're going to have a struggle for quite some time. So I want you to recognize that. I don't necessarily believe that you minimized to Ms. Sayer, because she did know about the prior drinking and driving offense. That was noted in her report. So I'm going to assume that you also told her accurately how much you drank, if you could remember that, and how much you had been drinking prior to that. And I think that needs to be in the back of your mind to make sure that you continue to do this for a fairly long period of time. Just as you created a habit of drinking to drown your sorrows, you're going to have to create a habit of not drinking when those temptations come up again in the future. So I believe that you can do all that. I just need to have you do that for a sufficient time so that it really takes hold and becomes a habit. All right. It will be the order of the court that you be placed on probation for 180 days. And again, that's not really a punishment. That's just a way for us to make sure that you know that we're watching so that this becomes a habit and you have a reason to continue to do the good things that I think that you've already been doing. There is a crime victim fee of $75, a justice assessment of $50, court costs of $400, a fine of $200, a local charge of $15. There is a $180 oversight fee for the probation. Let me add up those things. It's a total of $920. You can pay that off over the course of your probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation officer. You must enroll in and successfully complete the educational and treatment programs outlined in your substance abuse summary, which I'm also going to require you to go to the alcohol highway safety education class and to the victim impact panel. I believe that those will assist you in giving you good information so that you know how to make proper decisions in the future. Those are entirely educational, again, not designed to be a punishment, but to help you in your journey towards and continuing towards sobriety. How often are you attending AA meetings now, ma'am?
I try to at least do one once a day at 10 o'clock. There are some days that I haven't, but I try to do it regularly. And I've been sending all those to my lawyer.
All right. So would it twice a week be a something that would be fairly easy for you to do?
Yes. Right.
All right. If you want to do more, you certainly can. And I think that's entirely good for you to be doing that, especially early on in your journey down that path. But over the course of the next 180 days, I want you to do at least twice a week to remind yourself of those requirements. No consumption or possession of alcohol or drugs. No entrance into a business where alcohol is served by the glass. That means you may not go into a bar, even if it happens to serve food. You may, however, go into a restaurant, even though it happens to serve alcohol. You simply may not go into the bar portion of the restaurant. Do you understand the difference between those two things?
Yes, Your Honor.
All right. There will be testing as ordered by the probation department. That means they could do it on a daily basis. They could do it on a weekly basis. They could do it on a random basis, but that's up to them. And they'll do that after discussing those things with you as well. As I said before, there will not be any jail. I don't necessarily believe that work camp is appropriate for you given your physical limitations, so I'm not going to order that as well. Do you have any questions about the sentence, ma'am?
No, I do not, Honor.
Mr. Blumberg?
No, Judge, thank you. I do not.
Mr. Fourtier?
Nothing further, Your Honor. Thank you.
All right. Good luck to you, ma'am. I hope things go well.
Thank you.
Thank you,
Your Honor.
Judge.